Hey there, welcome to Broadband Deployment News. So, what does fish monitoring have to do with future net neutrality regulations? If you want to find out, stick around. Thanks for joining me. Rick Husey here with Broadband Deployment News. So, you wouldn't think these two things are related, but they are in a way. You see here Supreme Court to hear case that could weaken FCC. And when they talk about weakening the FCC, they really mean weakening every agency in the United States government as far as what powers they have to interpret legislation, basically, and what kinds of regulations they can put on companies, businesses, et cetera, if there's not clear, if it's not clearly defined in the legislation. So we're going to talk about this and what this all means. I'll look through this article, and then I want to talk specifically. Oops, sorry about that. I talk specifically about a couple of concepts in law that are impacting this, one of which is referenced in this article. So you see here at issue is court deference to regulators subject matter expertise. The Supreme Court has agreed to hear a case early next year that could impact how much regulatory discretion the FCC has over the communications industry. And again, this really applies to any government agency and any particular and their power there. But this certainly, net neutrality is a big thing that this is going to impact. And this may be why the court decided to take this case. I think they want to clear this up so that in the future, there's clear precedent for this. The court agreed Friday to hear the case of Relentless Inc. et al., and others, I guess, versus Department of Commerce and others. The case is about federal rule requiring fishing companies to pay for government monitoring of their herring catches. So I guess there's some kind of a rule that said we need to monitor, or someone's going to be monitoring the fish that you're catching, the herring that you're catching, and you're going to have to pay for that. The new Civil Liberties Alliance, or the NCLA, challenged the rule as beyond the regulatory scope. Congress gave the U.S. Department of Commerce's National Oceanic and Atmospheric Administration, or NOAA, and its National Marine Fisheries Service, NOAA Fisheries, which implemented the rule. While the case may be about fish monitors, it's also about the Chevron Doctrine, which is a principle of administrative law that holds that courts should give deference to a regulatory agency's subject matter expertise when it comes to interpreting unclear statutes. So I wanted to talk a little bit about that. I talked about this a week or two ago when the FCC first said, hey, we're going to go ahead and implement net neutrality regulations again under Title II of the Communications Act of 1936, I think it is. So this would impact that. So basically, this Chevron Doctrine, kind of the history of that. So in 1963, the Clean Air Act was passed, which is obviously to protect the environment. Then in 1977, that was amended to say that any new sources of pollution needed to go through this new sources review, which would be having to then get things approved. Those, lots of regulatory hassle, I guess, involved with that. But anyway, the EPA did not have clear, really discretion on that, or they had discretion, but they didn't have clear information on what that meant. So when you saw the term new sources, it was not clear what that was. So the EPA came out and they said, well, any significant change that you'd be making to your facility, your factory, your plant, or whatever, any significant change, that equipment then needs to run through this new sources process, this new sources review. So in 1981, and that was under the Carter administration, I believe, 1977, yeah. So in 1981, under the Reagan administration, that was changed. So the Reagan administration changed to where it was not just every single piece of equipment that you brought in needed to be looked at, but just your factory or plant in general. So if your factory or plant was going to be providing new sources of pollution, in other words, if you were increasing the amount of pollution from whatever was going on in the plant, then that then needed to be reviewed. But of course, if a factory or plant was reducing pollution in some areas and they were adding equipment and was maybe increasing in other areas, then it was kind of a net and didn't matter. So again, the point there, to reduce the regulatory burden on businesses so they don't, every time they're buying equipment or something that they're putting in their plant that they need to run through this review, they didn't need to do that. It was just all about the facility itself. Well, that was challenged. That was challenged later on as part of this Chevron case, I believe. So Chevron came out, and as part of that, that was the legislation that came out, the Chevron legislation. That was challenged by an environmental advocacy group that said they didn't like this 1981 decision and said it needed to go back to what it was originally, which was the fact that it was all the different equipment in the plant or the factory, and they lost. So Chevron won that challenge, and because Chevron won that challenge, they call it the Chevron Deference, or Deference, actually. So in other words, they will defer to the agency. The agency knows best, and in this case, it was the 1981 agency under Reagan that said they could determine that that new sources could be the factory as opposed to all the equipment. So Chevron won that case. The environmental advocacy group did not, and that is Chevron Deference there that we're talking about. And to go back to this article here, so you see the lack of clarity most germane to the communications industry is whether the FCC has the remit from Congress to decide whether broadband is a Title I information service, which is not subject to common carrier regulation, or a Title II telecommunications service, which is. And it's gone back and forth on the case law on that. You know, at one point they were saying the FCC did have the authority to say it was Title I, and later when the FCC wanted to make it Title II, I think some court cases have said they had the authority there. So there definitely needs to be some clarity here on which way it is. You know, if it's information services, that's one thing. If it's Title II, that's going to be much more regulation potential on internet broadband providers. In the 2005 Brand X decision, which was about the classification of internet access service, the Supreme Court ruled that Chevron Deference trumped an appeals court decision, and that the appeals court should have given deference to the FCC's conclusion that internet access was an information service, not a telecom service subject to mandatory access. So in other words, again, back in 2005, they decided, okay, well, the FCC knows best. They're the agency. So it's an information service. The FCC argued in defending its original open internet order that its authority to regulate ISPs as it did in the net neutrality rules stemmed from Chevron Deference. ISPs disagreed. So again, going back and forth on these things, according to Ballotpedia, all 9 Supreme Court justices have signed on to cases that call into question the doctrine. And they say, our clients have preserved this suit relentlessly, you might say, and we are eager to reverse the error. And this is, I think, from the attorneys of this relentless group. We're eager to reverse the error of the lower courts and remove the unfair and unnecessary thumb on the scale for bureaucracy against citizens that Chevron Deference inflicts on them when they face their government in court. And again, this was the counselor from the NCLA. So again, the main issue here at hand is whether an agency, which is an unelected group of bureaucrats, can actually make law and rules and regulations. Are they going too far if they come out and say, well, we're going to make broadband now something under the 1936 Communications Act? They have the authority to do that. And some would say in the past that this Chevron Deference would allow them to do that because they're the agency, they should know best, and they can determine kind of what Congress meant by the law. But more recently, there's something that has come out called the Major Questions Doctrine. So you've got the Chevron Deference Doctrine, you've got the Major Questions Doctrine, and the Supreme Court these days, especially with some conservatives on the court, has been leaning more toward this Major Questions Doctrine. For example, Kavanaugh served in the D.C. Circuit, which was looking at a lot of cases related to the government agencies, and we know he goes in that direction. We know that Amy Coney Barrett does. So it seems like the court is going to make a bit of a change here on these two things. So I wanted to talk about, let me bring this up, about these two things. So this is about the Chevron Deference. So you see here, this was in a court case, an opinion by John Paul Stevens. This was where the Chevron Deference was decided or became defined, I guess. It upheld the EPA's interpretation, which at that time was, again, that it was more about the factory or the full plant and not the individual pieces of equipment. It says a two-part analysis was born from the Chevron decision called the Chevron two-step test, where a reviewing court will determine the following things. They'll say, first, always is the question whether Congress has directly spoken to the precise question at issue. If the intent of Congress is clear, that is the end of the matter. The court, as well as the agency, must give effect to the unambiguously expressed intent of Congress. So again, if Congress is very clear on the issue, then there's there's no question about it, and the agency needs to do what Congress said, and companies need to do what Congress and the agency says, because the agency has full authority to implement what Congress said. It says here, though, if, however, the court determines Congress has not directly addressed the precise question at issue, the court does not simply impose its own construction of the statute. In other words, the court doesn't come in and say, okay, well, we're going to figure this out. It says, rather, if the statute is silent or ambiguous with respect to the specific issue, the question for the court is whether the agency's answer is based on a permissible construction of the statute. So in other words, in that case, if it's not at all addressed or if it's ambiguous, then under Chevron Deference, then the court will say, well, looking at this specifically the way it was stated in the act and the law, and then the way that the agency is doing that, it looks like what they're doing is permissible based on that. So they will weigh in on whether it's permissible or not. That was the Chevron Deference. But now, again, like I mentioned, we've got this idea of major questions doctrine. So you see here, John Roberts summarized that. It says, John Roberts summarized the major questions doctrine in the landmark case of West Virginia versus the Environmental Protection Agency in 2022. It says, in certain extraordinary cases, both separation of powers principles and practical understanding of legislative intent make us reluctant to read into ambiguous statutory text. The delegation claimed to be lurking there. So in other words, he's saying the court should not be involved. If it hasn't been addressed at all, or if it's ambiguous, they don't want to weigh in on whether the agency has the ability to implement that. It says here, Utility Air 573 U.S., that's the case, I guess. To convince us otherwise, something more than a merely plausible textual basis for the agency action is necessary. The agency instead must point to clear congressional authorization for the power it claims. As for the major questions doctrine, it took hold because it refers to an identifiable body of law that has developed over a series of significant cases, all addressing a particular and recurring problem. Agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. Scholars and jurists have recognized the common threads between those decisions, so have we, and they mention a bunch of cases here. So again, the court now is leaning in this direction, saying that if it's not clear, if it's not really clear that Congress granted an agency to have this authority, well then the court should not be involved. In fact, what the court is saying, it needs to go back to Congress. Congress has not addressed it. The agency doesn't have the ability to make those changes, and if the changes need to be made, it needs to be going back to Congress. So how this affects, obviously, Title II and whether a broadband service will be classified as Title II communication service, where the FCC can then regulate it under that, there's nothing at all clear in the legislation. I mean, there's basically two pieces of it. There's the 1936, I think it was, Communications Act. There was basically very basic phone service back then. And then there was the act, I think it was 1996, Telecom Act, that clarified some things. And in that act, they actually had separated it as information services and as telecommunication services, whereas information services were described as being internet services. So if it shows anything in the 1996 Act, it's that Congress was thinking about those two things separately, information services and telecom services. So I believe what's going to happen here is the court is going to look at this. This is going to be one more bit of case law where the court's going to look at this Fish case, and they're going to say that the agency in question, I'm assuming, there's nothing in the particular act about this NOAA Act that says that if you are a fishing company, that the government can say, hey, we need to monitor your fish catching practices or whatever it is that they're monitoring, and you're going to have to pay for it. I'm sure there's nothing in the act that says that. So I'm sure that the Supreme Court will come out and say, no, you can't do that based on this major questions issue and whatever else they might throw in there, that this agency does not have the ability to force these fishing companies to do that because that is not clear in the act. And that is something that would, I guess, have to be done through an amendment to the act, that kind of thing. Or it just, the government will have to pay for it. So the government can't, again, do these major things where you're forcing somebody to pay for something if it's not specifically in an act like that. So this has real ramifications, not just for net neutrality, but for everything that's being done, because a lot of agencies, again, they've had a lot of power. They're not elected really what they're meant to do is to implement these laws, these congressional acts, but they're not meant to add on top of them and to add additional rules and regulations on top of that if it's not specifically addressed. So Congress needs to do a better job maybe of laying out what needs to be done, and then also, so they need to do that, and then maybe get involved later and amend some of these things if there's not a clear question. So a lot of people think that Congress should be getting involved in net neutrality. Some think it's fine. I personally think Congress does not need to get involved unless we start having problems with net neutrality, which we don't at this time. So if people start to, if internet service providers start to take advantage, then that maybe needs to be addressed. If big tech continues to do what they've been doing as far as maybe stifling free speech and determining who can see what and when, that maybe needs to be addressed. But all of that stuff needs to be addressed by Congress, not necessarily by an agency that hasn't been elected to do so, unless it's very clear in the legislation. So when Congress lays out legislation, they try to think of everything they can. So they try to say, okay, for example, the IIJA, FCC, I think that was in there. FCC, you need to make a better map. You've got to make a better map because the maps stink, right? So that was part of the act, the Broadband Data Act, I think it was called. And, there's certain things that are laid out that then the agencies then have to implement because it was something that they've been told they need to do, and they need to do that, and they get it done. But if it's not something that Congress said that they need to do, or that described in a way that they should be doing, or it's very ambiguous, then it looks like the courts are going to say you can't do that. So that will impact net neutrality. I also linked in the description, I linked to this article, and I linked in the description something that I referred to a few weeks ago. It was a paper written by a couple of former Obama administration officials that talked about the fact that that the Biden administration should not be pushing ahead on net neutrality because it's just going to be stricken down by the Supreme Court. They're wasting their time. They could be spending their time doing something that will actually have an impact that won't be pulled back again because the court will wind up overruling it. So I'll link to that as well. And what this, again, this shows you why we need Congress to step in, because this goes back and forth. If it's not clear, then you get one administration in that changes the rules and says, okay, it's this way. And if you have this Chevron deference in place, then the courts may say, okay, well, you're the FCC, you should know best. You can interpret that way. Then you get another FCC in and they say, well, we think it should be this way. And it winds up going back and forth. So Congress either needs to be clear about it. And if Congress doesn't act on it, then the FCC or whoever the agency is that's trying to implement something does not have the authority to do it. All right, hopefully that will help you understand what's going on here. That'll be interesting to see how that all plays out. And again, I see why they're getting involved in this, not just from the FCC's perspective and net neutrality, but all of these other agencies trying to put, again, some case law in place that makes it clear what agencies can and cannot do. And it's going to be greatly limiting what they can do if something is not specifically outlined in the particular act that they are following through on. So thanks for joining me. If this was helpful, if you give me a like on the video, I'd appreciate it. If you're not subscribed to our channel, click the subscribe button and you'll be subscribed to our channel, but click the bell if you want to be notified when I'm live. I appreciate you joining me today. See you next time. Bye-bye.